Just a quick one today, because I'm snowed under with work. But somebody raised an interesting question. They said, is it significant that in the Lucy Letby case, both prosecution and defence senior counsel came from the same chambers? Well, I can tell you now, no it isn't. This is not uncommon at all. But it gives an opportunity just to explain how the bar works, how the self-employed bar works, and how this, is a very common scenario. So let me just briefly explain how you become a barrister. You go off to law school and you do what we call a qualifying law degree. That's a law degree that covers certain subjects, certain key subjects, like contract tort, trust, I think European law. I was quite lucky because I just managed to avoid the European law one before they came in. And now it's all irrelevant, I suppose. But you do your law degree, or you can do any degree, and then you do a course that converts any degree in any subject into a qualifying law degree. I mean, basically they just teach you over the course of a year or however long, 2 years, do it part-time. They just teach you all the core subjects. So you got your law degree. Then you go off to bar school, and that's just a 1-year course. I'm old enough for when it was just there was just the bar school, the Inns of Court School of Law, but now it's been franchised out. I think there's about 11 course providers, various universities do it and various law schools. Now, once you have passed bar school, you are entitled to be called to the bar, and indeed you will be called to the bar. You're in of court. There'll be a nice little ceremony where you go along, you get called to the bar. At Middle Temple we sign a little book, no oaths to anybody, I hasten to add. But we signed a little book on a table that was the hatch cover off the Golden Hind, and you are called to the bar. However, you are not fully qualified. Now, you can go off, lots of people do go off and just work in-house for sort of legal departments, or they may go off and do something that's not legal, but the bar qualification is quite handy to have. But what you can't do is at that stage you can't represent anybody in court. You don't have rights of audience. To obtain rights of audience, you need to do what's called pupillage. I quite often describe pupillage as like an apprenticeship, but that's not actually quite correct, not least because they are going to actually introduce, the BSB are looking at introducing proper apprenticeships, so you can study everything. Forget the law degree and the bar school, you just do it as an apprenticeship, which I quite like, because the bar never used to be a graduate profession, and looking at bringing that back. So pupillage is where you're under the supervision of your pupil supervisor for a year. After the first 6 months, your first 6, you get a provisional practice certificate, which actually allows you to do anything a fully qualified barrister can do. I mean, you could get your provisional practice certificate and appear in the House of Lords the next day, or the Supreme Court, whatever it's called this week. At the end of your 12 months, if it's satisfactory, you get your full practice certificate. Again, showing my age, I remember when once you got your practice certificate, that was it. It just lasted forever, but now you've got to renew them every year. Just for extra fee generation. But then you are a fully qualified barrister with rights of audience in every court in the land. And again, like I say, you can actually go off and work in-house if you want to, but most barristers in chambers, we're self-employed. So how do we work together? Well, barristers aren't actually allowed to form sort of limited companies or partnerships or anything like that. I say that, there is actually now a way you can do it. They're called alternative business entities. And what I'll do is I'll flag up Mr. Dan Shensmith, because he knows a lot about these, because he was actually quite heavily involved in setting these up. But I won't go on about that because I'm a traditionalist. So the old way was you applied for a tenancy in chambers. So you became a tenant in chambers. But what are chambers? Well, chambers are just unincorporated associations. It's just a bunch of barristers who get together and collectively agree to sort of pay expenses like chambers rent, chambers staff, management, people like that. Usually done on a sort of percentage basis of fees, sometimes with a fixed fee element. So it might be, for instance, it's like every month you will pay X amount plus a percentage of whatever work you have done you have generated that month. But like I said, chambers are unincorporated associations. They're not companies, they're not partnerships. They are just a bunch of barristers collectively, working together. Sometimes chambers will set up service companies to, do things like if they're renting a building or something, they might have a service company to be on the contract, and all the members of chambers would be, directors or shareholders of the service company or something like that. But chambers themselves are just a bunch of people together. Now we all sort of work from home and we communicate with the court electronically. You're not physically in chambers as much. But even when you were, you are quite separate. You are, it's nice to be in chambers because you've got your friends and you can sort of chat to people. But you are just a self-employed barrister. So you can act for any client you want, and that can be, you can act for the prosecution in the case, you can act for the defence in a case. Even when you've got part-time judiciary, and I've had this situation a few times where somebody like a barrister will sit as a recorder in the Crown Court, that's a part-time judge. I've had it where you've ended up with all counsel and the judge all from the same set of chambers. So that in itself is not, unusual. But what about confidentiality and things like that? Well, yeah, obviously you make sure that, the other side don't, your learned opponents don't see anything confidential. But, we do chat about cases, but people do that anyway. I mean, solicitors will always communicate with each other to try and settle things, or just to try and do housekeeping when things are progressing to trial. They will normally do it, though, in writing, or if they do it by telephone, as soon as the telephone call has ended, one or the other will create an attendance note recording what was said in the telephone conversation, and they will send it off to the other side and say, this is my recollection of what we've just discussed. If you disagree, please say so. So that's how they handle things like that. It's a lot more formal. Now at the bar, we quite often have what we call counsel-to-counsel conversations, where it's barristers just chatting to each other. And the understanding is that not only is everything without prejudice, it's just generally, it's just between ourselves. So that could be something as simple as housekeeping. It's like, well, shall we just agree with ourselves that we'll swap this evidence by this day, or we'll serve witness statements by this day, or we'll ask the judge for this, to do this or to do that. And we tend not to record those in writing. Now we do quite often get told off by the judiciary and the Bar Standards Board saying there is no such thing as counsel-to-counsel conversations. Nothing in there has any protection whatsoever. However, the bar's such a small profession that if anybody was to try and pull a fast one on that, they'd just be persona non grata pretty much forever after that. So I cannot think of a single incident where anybody's ever tried to pull a fast one. And indeed, all that judicial commentary is where people have done things, and it's like the argument is that was covered by counsel to counsel, and it's whether or not it was, or so that's been the discussion. But barristers themselves tend to understand that the whole point of trust of this is it builds trust, and it just saves time, and it means we can be cooperative and progressive and get on with things. But yeah, like I say, there's nothing unusual whatsoever, because technically speaking, everybody's just a self-employed person being instructed by the CPS or defence solicitors. They can do what they want. You sometimes you'll build what are called Chinese walls. Where it's like, okay, we'll keep all our documents in this room, you keep all your documents in that room, and we won't sort of discuss this between ourselves, and we'll keep quiet and make sure we're not overheard and anything like that. That's more something that happens at solicitors firms. It's not uncommon actually for big solicitors firms to end up acting for different parties. And they can, if they're big enough, they can do that. If they can assure everybody that, look, this is totally independent, and that there will be no sort of behind-the-scenes conversations or leaking of confidential material or breaches of GDPR. Like I say, that in itself is a sort of a very common thing. But yeah, with the Letby thing, nothing whatsoever unusual. I mean, it can be quite cooperative, because it may well be that they just got their heads together for simple housekeeping things like, look, here's the timetable for the trial, here's the list of witnesses, shall we sort of work out what dates people to attend, shall we just work out when you might need this material or you might need that material. And judges like that. Judges like it when people are cooperative and helpful. So there you go. I mean, like I say, I've padded that out quite a lot just to give you the history of this, but the simple answer is no, there's nothing even slightly unusual or untoward in the fact that counsel from opposing sides were from the same chambers. So there you go. I'd better go back to work now. But as always, hope you found that vaguely interesting, vaguely useful, vaguely accurate. Vaguely accurate. Yeah, the usual stuff.